Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. The big question, is marijuana still a Schedule I controlled substance? Well, a man by the name of Tony Jezzy of Allegheny County recently challenged that classification in the Pennsylvania Superior Court. Here are some of the facts. A confidential informant had tipped off the police that Jezzy was packaging and distributing marijuana from his home. Police did a trash pull and found a large quantity of marijuana residue in one bag and loose marijuana in another bag. Police got a warrant and found about 40 plants in his home. Why people put marijuana residue in bags of marijuana out on the curb for trash removal and don't worry about someone like the police finding out about it is beyond me. In any event, Mr. Jezzy was charged with the following offenses. The crimes: 1. Possession with intent to deliver marijuana. 2. Possession of marijuana. 3. Possession of drug paraphernalia. All criminal offenses under the Controlled Substances Act. Jezzy filed a motion in court challenging the continued classification of marijuana as a Schedule I controlled substance under the Controlled Substances Act. He was arguing that it should no longer be a Schedule I controlled substance after passage of the Medical Marijuana Act. In short, he claimed the Schedule I classification of marijuana denies Pennsylvania citizens equal protection under the law because the Controlled Substances Act states marijuana has no medical use, and that's one of the reasons why it's a crime to have it. But the Medical Marijuana Act, well, it sets up a medical marijuana production, distribution, and certification program for those who are medical patients or medical patient caregivers, so it obviously has a medical use, according to Mr. Jezzy. Seems like a common sense conclusion that he's reached, doesn't it? Well, not so fast. The trial court denied his motion. He was convicted of all 3 charges, and he appealed. Now, on appeal, he continued his argument that the continued criminal classification of marijuana as a Schedule I controlled substance is irreconcilable with the Medical Marijuana Act because, according to Jezzy, the Medical Marijuana Act must mean marijuana has a medical use. Well, the Pennsylvania Superior Court disagreed. It held, in essence, the Medical Marijuana Act creates a temporary program for qualified persons to access medical marijuana for the safe and effective delivery of medical marijuana and for research into the effectiveness and utility of medical marijuana. Significantly, the Medical Marijuana Act does not declare that marijuana is safe and effective for medical use. And the Medical Marijuana Act was not intended to remove marijuana from the list of Schedule I substances under the Controlled Substances Act. Now, another note is the court used the rational basis test, which is the lowest burden for the Commonwealth to satisfy in defense of the constitutionality of a statute. That means the court did not find that the criminalization of marijuana affected a fundamental right or even an important right. So no, you do not have a fundamental constitutional right to smoke marijuana. Furthermore, the court reminds us that our Commonwealth may criminalize the possession, manufacture, and distribution of marijuana and other intoxicating substances independent of their medical utility as a function of the police power of the state. And the reasonableness of such measures is largely at the discretion of the legislature, and courts do not like to intervene and override the legitimate public policy determinations made by legislatures asserting their police power. Then the court made the determination that the Controlled Substances Act furthers the legitimate government interest of public safety by protecting the public from unfettered access to unsafe substances. And there you have it. In short, the court is basically saying the regulation of marijuana is a matter best left to the General Assembly and not the courts. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law Thanks for listening and enjoy your lunch.